My Lord, the President of the Court of Appeal, my ladies and my lords, my name is Nelson Havi. I appear together with Esther Angawa for the first to fifth respondents in the consolidated 4 appeals. And the respondents are Dr. David Ndii, Jerotich Seii, James Gondi, Wanjiru Gikonyo, and Ikal, Angelei. On 27th of August 2010, the people of Kenya promulgated a constitution. It was a perfect charter that defined the system of government. It created a pure presidential system with one executive, unitary. It created a minimum of 14 and a maximum of 22 cabinet secretaries. It created a parliament of 290 constituencies in the National Assembly. It also created a judiciary that was independent and accountable. There are those who have found fault in that constitution. They have proposed a total of 74 amendments. Within the stroke of the pen, which proposal dwarfs a total of 38 amendments effected on the Independence Constitution from 1963 to 1991. Our submissions are structured as follows. I will address the judicial authority over political actions and decisions, the legal underpinning for the basic structure, eternity, and amendable clauses doctrines, amendment and dismemberment, constituent power, popular initiative and constituent power, the President and constituent power, the effect of the Constitutional Amendment Bill 2020 on the basic structure. My colleague Esther Ngawa will address quorum of the IEBC, the role of IEBC in verification of signatures of supporters of a popular initiative, voter registration, public participation, referendum questions, and referendum law. The question on the basic structure was determined at paragraph 469
Sorry,
of the judgment.
Mr. Havi, are you comfortable there or you'd want to use the podium?
I'm comfortable here because I want to have maximum use of my
Okay,
books. Yes.
thank you.
Thank you, my Lord. My Lord and my ladies, it was the finding of the High Court that the basic structure, eternity clauses, and unamendable clauses is applicable in Kenya. To that extent, the High Court defined what the basic structure is. It stated that the basic structure is the constitutional core edifice or its essential features. The court further indicated that these 2 doctrines are identifiable from an examination of the history and the text of the Constitution itself. The court proceeded to say, and this we'll find at page 176 or paragraph 473 of the judgment, and I may quote, "To be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable." So the doctrines are explicit. Sorry, they are implicit, they're not explicit. The court proceeded to indicate that insofar as the basic structure is concerned, an alteration is permissible, but only through the exercise of the constituent power. And the exercise of the constituent power was premised upon 4 sequential steps: civic education, public participation, debate, and a referendum as the ultimate process. Now, the question that arises, and which the appellants dwelt upon at length, was that the doctrine of constituent power is not textualized in the Constitution of Kenya and is inapplicable. May I take the court to the decision upon which this doctrine is domiciled in Kenya's jurisprudence? And this is the case of Ndii and 5 others versus the Attorney General. It appears in volume 2 of my bundle at page 642 all the way to page 728. And you will find at page 677, the anchoring of the constituent power. And this is what Justice Aaron Ringera said about the constituent power at page 677. Indeed, it is not expressly textualized by the Constitution, and of course, it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they will do so only ex abundanti cautela, out of an excessiveness of caution. Now, this doctrine did not originate with Justice Aaron Ringera. It is my submission that the doctrine permeates the entire history of democracy. You will find this doctrine elaborated by John Locke in the 2 Treatises of Government. Volume 1 of my submissions at page 247. This is how Locke defines constituent power. He defines constituent power as the power to form government. He proceeds to say constituent power connotes the subordination of the power of the Commonwealth. And the Commonwealth here refers to the civitas, civil government. Baron de Montesquieu, writing about the spirit of the laws, which you'll find at volume 1, in particular at page 318, identifies that constituent power.
Yes.
It is therefore my humble submission that constituent power is traced to antiquity insofar as democratic governance is concerned. It is not an emergent concept, it is not alien. May I conclude that particular part with what renowned professor of law Ben Ndii states about constituent power. And you'll find this in volume 2 of my bundle, in particular at page 496. Page 496. This is what Ndii states at page 496. The chapter is titled Presidentialism and Constituent Power. I will revert to the issue of the president and the constituent power. In the concluding line of the paragraph, it is a power to constitute a frame of government for a community, and a constitution is the means by which this is done. In essence, therefore, it is the sovereignty. It is my humble submission that with those precise arguments based upon the law, we have founded the existence of the constituent power within the realm of constitutionalism. We need not look any further. Now, having identified the constituent power, we now proceed to consider the legal underpinning for the basic structure, eternity, and unamendable clauses and doctrine. Again, permit me to go back to the Ndii case, where the basic structure doctrine, in my humble submission, finds the first application in Kenya's constitutional jurisprudence. And this is what Justice Aaron Ringera said at page 688. Page 688. I've highlighted it. He says, all in all, I completely concur with the dicta in the Kasevenanda case that Parliament has no power to and cannot, in the guise or garb of amendment, either change the basic structures of the Constitution or abrogate and enact a new Constitution. What was the context in this matter? An entire abrogation of the Constitution was sought on the basis of Section 47 of the retired Constitution. The court said, no, for you to alter that system of governance, you must go back to the constituent power. Speaking about the constituent power and the basic structure of the Constitution, and here you recall the question that was posed by Justice Kiage to Senior Counsel George Oraro. Can the people of Kenya, through their majority, resolve to remove or abrogate Parliament? What was his answer? He said yes. Permit me to take you back in history. When is the pivotal moment in the history of the world when this was attempted? It was in 1933 by Adolf Hitler. And history records that of all European leaders of that time, it is only Adolf Hitler who ascended to power with an overwhelming majority at the ballot. Now, let's see what Justice Aaron Ringera said about that issue. He proceeds. In my judgment, the framers of the Constitution could not have contemplated or intended such an absurdity, the removal of Parliament. And it will not be an answer to that concern to say, as was said by counsel for the second respondent, that the people can't change their Parliament. It is as simple as that. Now, let's domicile the basic structure in text. And I will take you back to Professor Nubweze writing about presidentialism in Commonwealth of Africa, and still on the topic of the constituent power. And permit me to emphasize, when Nubweze writes, it is not a suggestion, it's not a concept. He indicates what the law is. And for those without the benefit of good learning, this is the point. If you go to your library, you will find the common law texts. For instance, we have Chiti on contract. Chiti writes the law. We have De Smith on constitutionalism. De Smith writes the law. We have Gawa on company law. They write the law. So that when we find these postulations in the written works, they're not suggestions. They are the law. Now, we go back to page 496, where Ndii talks about the basic structure. And in particular, you'll find this at page 500 to 501. 500 to 501. If I may go there pretty fast. So we start with page 500 at the bottom where it starts as follows. A constitution is supposed to be a permanent charter which is to endure for ages to come and not to be lightly altered to meet the temporary expedience of political parties. And my lords and my ladies, as you pause there, let me take you back to the preamble of the Constitution of Kenya so that the significance of these points may sink. This is what the preamble says in introduction and in conclusion. We, the people of Kenya, then after enumerating all those recitals, says, adopt, enact, and give this constitution to ourselves and to our future generation. Now, if any scholar of law or litigator were to ask you to locate the basic structure doctrine in the Constitution, then the answer will be, can you locate for me the doctrine of separation of powers, checks and balances, and independence of the judiciary? Now, we go on and see how Professor Ndii has applied this basic structure to the Kenyan situation. And you will find this at page 526 of volume 2. 526, my lords and my ladies, 526. And I've highlighted at 526, but I'll proceed straight ahead to page 527. And the background is this. He has examined all amendments in the Independence Constitution at the time of his writing in 1973. And he has categorized them into two: the strict power of amendment and the power of repeal. And before I read what he has said, he concludes that there is a dichotomy between amendment and repealing. And what in actual fact happened to the Independence Constitution were not amendments, they were a repeal. This is what the renowned scholar of law says. This alternative method that was used initially in Kenya appears to be legally unimpeachable, the alternative method. Since the power to alter the Constitution was rather widely defined to include amendment, modification, or reenactment, with or without amendment or modification. And here is where we underline. However, applied to the Independence Constitution, but not to the Order in Council itself, it may be doubted whether the spirit of the amending power contemplated the destruction through the superimposition of a republican presidential form of the system of government instituted by the Constitution, namely monarchical parliamentary government. The so-called amendment, in fact, established a new constitution, and as such, should have been effected by the repeal of the existing Independence Constitution. He says this in 1973. Is he alone when he says this? No, he's not alone. He is joined by Justice Aaron Ringera many years later. And this is what Justice Aaron Ringera said, commencing from page 688 at the last paragraph. Before I leave this aspect of the matter, let me comment on the previous amendments to the Constitution of Kenya. Since independence in 1963, there have been 38 amendments to the Constitution. The most significant involve a change from dominion to republic status. The dominion was this: there was a governor general, and then there was a prime minister. There was the lower house and the upper house. What we commonly refer as to Madaraka Day is the day that we were given a prime minister. Within 6 months, by December 12th, what we commonly call Jamhuri Day, the Constitution was abrogated to eviscerate the dominion status and install a presidential system. Now, Ringera proceeds. Abolition of regionalism, what we now have as devolution, change from parliamentary to a presidential system of executive governance, etc. And this is how the learned judge, and he was indeed very learned, concludes. The effect of all those amendments was to substantially alter the Constitution, substantially alter the Constitution. Some of them could not be described as anything other than an alteration of the basic structure or features of the Constitution. And they all passed without challenge in courts. My ladies and my lords, before Copernicus, before Columbus, there were many things about the earth that were not known. They are now known. The fact that we did not know something 10 years ago did not mean that we were foolish then. We were not wise. We've just grown wiser. He concludes, all I can say that is, in that respect, is that unfortunately or fortunately, the changes were not challenged in the courts, and so they are part of our Constitution. Now, fortunately for us, the 74 proposed eviscerations on our permanent charter were successfully challenged before the High Court. The High Court agreed with us. It is my humble request that you uphold the finding of the High Court on that issue. I will not...
Mr. Havi.
My Lord.
Mr. Havi.
My Lord.
I follow your argument, but I'm just wondering, the wisdom you speak of, past Njoya, the Njoya decision was in 2004, is it?
2004, my Lord.
2004.
Yes.
He speaks very clearly about the place of the Constituent Assembly, right?
Yes.
Now, when you come to our Constitution, 2010, you have this chapter which talks about, I know you're looking at your watch, yeah, time. It lists those chapters that cannot be, or rather sections, that cannot be amended without reference to the referendum. My question is this: why is it that we were able to incorporate the referendum, but we did not include the Constituent Assembly, which now the judges of the court below actually say is an important aspect in that process?
Yeah, my Lord, you're right. Your question is quite germane. And it is partly answered by Justice Ringera, and it is also answered by other scholars. And that is why Justice Rengera said, if we don't have a referendum in our law, it is implicit. Out of abundant caution, we have included the referendum. But, my Lord, let me trace the origin of the constituent power, because it is my humble submission that the constituent power is that which is in us. In French, it is called pouvoir constituant. It is almost traced back to God. It is in the category of what we call inalienable rights. For instance, I have the right to life. You may textualize it in the Bill of Rights. You may not textualize it in the Bill of Rights, but it is my right. Let me give you a more basic example. Childbirth must happen after 9 months. And there's a manner of happening of childbirth. If it is textualized, it is for the benefit of medical learning, but it doesn't change the mode. Have I answered your Lordship?
In a roundabout kind of way, you've attempted. Carry on.
Thank you. My Lord.
Mr. Havi, just on the same issue, what's your view? Were the principles espoused by Rengera J in the Njoya matter realized by Kenya in the making of the Constitution of Kenya 2010?
They were realized to a certain extent. For instance, the referendum was textualized. The constituent power was not textualized. Public participation was also provided for in various aspects, commencing from Article 10, going to Article 118 and 119. But the premise upon which we seek to support the decision of the High Court is this. Even if they were not there, we are duty bound to follow them. There is an argument between Princess Anne and President Lyndon Johnson as to the efficacy of the Westminster model vis-a-vis the presidential system in the United States. And Anne told the president, if you are accustomed to mediocrity, you will find fault in perfection, referring to the English system of governance. Because in England, scholars will say that England does not have a written constitution. The fact of the matter is that England does not have a constitution. That's the fact. What England has is demonstrable, perfected constitutionalism. So that these doctrines in here, and they apply whether or not they are textualized.
All right, move on.
Thank you, my Lord. My Lord, I will be doing an injustice on that topic if I did not acknowledge the works of Professor Richard Albert on the basic structure, which you will find I have extracted at page 1281. And Richard Albert says this, writing about how courts become supreme in defending the Constitution from unconstitutional amendment. He says that it is the duty of the court to defend democracy. Another writer whose mention requires immortalization for the purposes of these proceedings is Yaniv Rosnai, writing about populist constitutionalism and unconstitutional amendment doctrine. Again, he formulates the doctrine of constitutional capture. And because this is very relevant, permit me to cite and quote in brief what Rosnai states at page 1304. Of volume 4. He formulates the concept of constitutional capture by a populist regime or leader. And then he concludes at page 1307, the last paragraph. 1307. This is what Professor Rosnai states. Abusive constitutionalism becomes especially attractive.
Yes.
1307 at the bottom.
Yes, go on, we are with you.
Abusive constitutionalism becomes especially attractive with relatively flexible amendment processes controlled by a dominant party or the government. He proceeds, for example, what allowed the weakening checks and balances on the protection of rights in Hungary, effectively turning it into an illiberal state that fails to comply with minimum standards of constitutionalism. Here at home, and it is a pity that the few royal natives like Professor Githu Muigai and Professor Ben Sianya have not brought their works on this issue. Here at home...
Sorry, Council, what did you say?
I'm saying that the royal natives. You see, in England we have the lords, and here we have the professors when it comes to the law. So the royal natives, Professor Githu Muigai and Professor Ben Sianya, have not written on this issue. But one royal native has written on this issue. His name is Professor John Mutaha Kangu. Mutaha Kangu. And his book is titled Constitutional Law of Kenya and Devolution. And if you look at volume 4 at page 1276, 1276, this is what the good scholar of law says. The basic structure of the Kenyan Constitution should include the sovereignty of the people, the supremacy of the Constitution, the principle of sharing and devolution of power, democracy, rule of law, the Bill of Rights, especially the right to human dignity, separation of powers, and the independence of the judiciary. And then he concludes, just as the judges of the High Court concluded, that you cannot exhaustively enumerate which clauses in the Constitution to which to attach the basic structure, eternity clauses, or unamendability. He says, nonetheless, implied non-amendable aspects of the Constitution can be identified.
Council, flowing from that, I think the argument was made that if that be the case, the courts would have to be approached at every turn to determine what that comprises. What do you say to that?
My Lord, I listened to that submission with a lot of disappointment. The court need not be approached anytime the amendment is proposed. The reason is this. The court is the final arbiter of interpretations of the Constitution, but not the only one. Under Article 10, everybody is obliged to apply and interpret the law when formulating policy or making a decision. It will therefore be incumbent upon any initiator of an amendment initiative, be it Parliament or Wanjiru, to make that inquiry. And my Lord, this is fundamental because under Article 94 of the Constitution, Parliament's fundamental role is to protect the Constitution. And before I part from that point, this Parliament identified 3 areas of unconstitutional amendments in the bill. 1, the installation of an executive prefect in the judiciary in the name of ombudsman. 2, the manner of creation and allocation of boundaries. And 3, the want of a legal framework to enable amendment, but they nonetheless passed the bill as it is. Why? Because they failed to comply with Article 10 and Article 94 insofar as they obligate. And my lord, it must sadden you that a legislator will come and tell you here that should we be coming to court every time we want to identify a basic structure? I think I've sufficiently answered that point.
It is not clear what the answer is to. So what is to happen if a proposal is made to amend? How is one to go about determining whether you are tampering with the basic structure or not? How do you make that determination?
My lord, the determination is to be made by looking at the history of where we've come from. For instance, we have a pure presidential system of government. And upon it is anchored separation of powers and checks and balances. So that when you initiate that amendment, you need to look at the history of the people of Kenya in constitutional making. But should there be need for the issue to be determined in court, it will be determined when it has become germane. Like in our case, the issue was germane. It was not in the realm of conjecture. So that conundrum is one that should not prevail at this juncture. And because I want to leave my colleague with a clear 1 hour, let me quickly deal with the popular initiative and constituent power. Now, I will take you to volume 1 of my list and bundle, volume 1. And here we are again referring to a scholar, a professor of law, Professor Albert Stern, Methods of State Constitutional Reform. And you will find the operative article at page 343. 343. And I rely upon this decision, page 343, it's a written text, to indicate that popular initiative is not peculiar to Kenya. There is a colleague of mine who submitted that we are the only ones who have domiciled this doctrine.
Yes.
If we can look at page 343, this is what Professor Stern says. In America, it is called the Constitutional Initiative. And in paragraph 1, the last 2 lines, it is regarded as an expedient which may be utilized in situations where the legislature has failed to act. Substantially, the device amounts to a reservation by the people of the power to alter the basic law in their sovereign capacity without resort to the usual process of legislation through representation. And then Professor Stern proceeds to conclude when he's evaluating the efficacy of the constitutional initiative in the United States of America, and this is what he says at page 60. Page 60 at subtopic evaluation. As a technique of amending the state constitution, the initiative has distinct advantages and disadvantages. On the positive side, one of the most significant advantages of the constitutional initiative is its availability as a popular weapon to combat domination of legislative bodies. And then he concludes in that paragraph, not only is the constitutional initiative a device for avoiding stalemate in the legislature, but it also serves other useful purposes. If properly utilized, it may be a device for popular education of important public issues. An admission was made from this podium by none other than the Attorney General. They are pending before Parliament a total of 22 proposed amendments to the Constitution. One of my colleagues will deal with how the government...
Is it pending or attempts that have been made?
They're still in Parliament, 22, and we have enumerated them in our petition, 22. So therein lies the mischief. You've seen legislators speak here and seek to ascribe to themselves the title Wanjiru. A legislator can never be a Wanjiru. It's as simple as that. And I will conclude with that point when I'm talking about the president and the constituent power. And straight to the point, we'll start with the definitions at Article 260 of the Constitution. Who is a person? Who is a public officer? Who is a state officer? The moment you become president, you cease being a person. You become a state officer. And if there is any doubt as to how you are supposed to exercise yourself, then recourse can be made to 2 or 3 examples. We will start with Locke himself at page 250 of volume 1. Page 250 of volume 1, 250. And this is very imperative. This is very imperative, page 250. And I don't want to read the entire treatise, but if you look at, starting from paragraph 151 at the bottom, this is what Locke concludes about a state officer, the monarch, the executive, who ceases holding his office, a hallowed office. But when he quits his representation, this public will, the protection he enjoys, and acts by his own private will, he degrades himself. He degrades himself. And he cannot come here and complain through the Attorney General of being insulted. And is but a single private person without power and without will, the members owing no obedience but to the public will of the society. Locke proceeds to indicate that doing so amounts to tyranny. He has also defined tyranny at page 272 to 273. But before I examine what Ndii states about the office of the president and whether or not he can exercise constituent power, permit me to premise the foundation from Article 131 itself. 131. Sub-Article 2, A and B. The president shall respect, uphold, and safeguard this constitution. There is no obligation of that kind on Wanjiru, Atieno, Nasmiu, Hadija, or Ndii. It goes at B, safeguard the sovereignty of the republic. There is no obligation on me to safeguard the sovereignty of the republic. Now, that is the office of the president. And we have seen what the sovereignty of the republic is. It is the constituent power. The president, like King David before him, cannot start taking the flock. The president, like King Edward VIII, must remain the president. If he wants to engage in the affairs of other lesser mortals, then he must abdicate. There are no 2 options to this matter. And to contextualize that quickly, we see what Professor Ben Ndii says at page 462 of volume 1, sorry, of volume 2. 462 of volume 2. At page 462, writing about the extent and the reality of presidential power, Ndii says the most striking feature of the presidency in Africa is its tremendous powers. Its formal powers exceed those of its American prototype, not in nature, but in extent. You now realize the lamentation of President Lyndon Johnson when they were having dinner with Princess Anne. And as he closes, this is what he says at page 483. The splendor that is of the president, page 483, last paragraph. The splendor is indeed part of the social preeminence of African presidents, the splendor. Personifying the state, writes Arthur Lewis, they dress themselves up in uniforms, build themselves palaces, bring all other traffic to a standstill when they drive, hold fancy parades, and generally demand to be treated like Egyptian pharaohs. If Professor Ndii and Arthur are lying, drive in the streets of Nairobi. The president is not a mere mortal, he is a superior mortal. Now, let me conclude with the effect of the constitutional amendment bill on the basic structure, eternity, and unamendable clauses doctrines.
Sorry, before you leave that, Mr. Havi, so your submission, following from what you have said,
My Lord.
would therefore be that Articles 27, 38, among others,
Yes.
cannot apply to the president?
The president cannot be party to a popular initiative.
No. I'm talking about Article 27, Article 38, among others.
My Lord, let me just go there. My Lord, they do not apply to the president. And I'll just give you one illustration. Let's look at Article 37. The right to assemble.
No, I'm talking about 27 and 38, among others. Can they apply to the president?
No, they don't apply to the president.
All right.
And the reason is simple, and it's in Article 37. Every person has the right, peacefully and unarmed, to assemble, to demonstrate. Imagine the president demonstrating or picketing.
Supposing, Havi,
My Lord.
supposing the president is president on an independent, as an independent, I think that picture was presented here, and he has a parliament which is running rogue. Can he not make an appeal directly to the people, go to the people who elected him and demonstrate in the streets of Nairobi against that parliament?
A story is told today, I think it was told today by retired Justice Kwach or Dr. John Khamenwa, that when there was a threat of toppling President Jomo Kenyatta's government, one Chief Justice joined the crowds to demonstrate in the streets of Nairobi, and it was ridiculous. But, my Lord, to contextualize what you're talking about, there is this documentary series, The Designate Survivor, the predicament of an independently elected president in the United States. It is a predicament. It may arise, it may not arise, but the fundamental proposition is this: Kenya is a multi-party democracy. You stand as no ball chance in hell winning the presidency in Kenya as an independent.
Supposing, because that was presented here, supposing Parliament doesn't listen to the president, Parliament has the majorities, and people in this country, people change, right?
Yes, my Lord.
If that happens, are you saying that the president cannot make a direct appeal to the people and join them in petitioning Parliament, for example?
No, my Lord, he cannot. If the president is such a predicament, he has to do which King Edward VIII did.
He has to resign.
He must abdicate and go and marry the American divorcee. It's as simple as that.
So what is the place of Article 1, Sub-Article 2 of the Constitution? Can Wanjiru speak through a state officer, even the president? Can Wanjiru present a request to a state officer and say that this is my petition, this is my request, can you, consider it and act on it?
But Lord, there is a reason why I refer to Professor Stan to create the conceptual framework of what in America is called the constitutional initiative.
Yes, and link it kindly to Article 1, Sub-Article 2, so that we make an informed decision regarding the question of sovereignty and the people exercising their power either directly or through their democratically elected representatives. Thank you.
Well, Lord, I agree. The question is quite appropriate. Under Sub-Article 2, the people can act through those two fora, directly or indirectly. When they do so indirectly, they do so through their representatives. When they do so directly, they do so in exercise of their constituent power. When all those other avenues, as Professor Stan says, have failed to yield results. But my Lord, because the...
Only when they have failed to yield results?
Yes, yes.
Okay.
And my Lord, perhaps now that you've asked that question, the answer that was given by Professor Nobweze may be apt here at page 496. Page 496 of volume 2. Yeah, he says, recalling again that the president under the presidential system in Commonwealth Africa is the organ that coordinates and therefore dominates the executive and legislative process of government, in particular, that it is he who, as executive, has and controls the legislative initiative. We ask the question whether his power in this behalf includes or should include constituent power. And when you progress with that chapter, Nobweze concludes affirmatively that the president can never exercise constituent power. And I may take you even further. Justice Wolfgang, who is also a professor of law in Germany, says this constituent power was not available to the monarch and is not available to the executive in a republican. No wonder, therefore, Germany had to entrench certain clauses because they couldn't entertain a repeat of what happened in 1933. Now, my lords and my lady, if you permit me to use these 13 minutes.
Yes, you can move on.
I want to interrogate the effects of the BBI bill on the basic structure. This is what the BBI bill has done: to destroy, to dismember, to eviscerate the basic structure of the Kenyan system. It has created an impure hybrid presidential and parliamentary system. And remember, Nobweze spoke about it concerning the change from dominion status to republic. This bill has domiciled the cabinet in the legislature, effectively obfuscating the functions of the executive and of the legislature. They may tell you we can't see separation of powers in the Constitution, but it's there. There is no separation of powers in what is intended. Thirdly, it has sought to interfere with the independence of the judiciary by installing an executive prefect in the name of Obchinsky, aka Ombudsman, to perform functions allocated by the people of Kenya to the Judicial Service Commission. Parliament itself acknowledged this fault. My lords and my ladies, I would have wanted to speak much about this issue, but it's an issue that now requires retirement. It requires retirement, and for me to retire, I will quote two people, Nobweze and Justice Ewan Krigler. For Nobweze, I will quote what he says about the mixture of the presidential and parliamentary system, this time specific to Ghanaian founder, Dr. Nkrumah. This is what he says at page 624 of volume 2. 624, my lord. I will take you. Remember, when we were studying GHC and history, we were told many good things about Dr. Nkrumah. But you see, when you study the law, you will understand many other bad things about Dr. Nkrumah. And this is what happens. At page 624, at the tail end of that page, the linkage of the executive to the legislature was reinforced by the provisions requiring ministers to be drawn from the legislature. That is at page 624. However, neither the president nor his ministers were responsible to the legislature. And so there was no question of his being forced to resign because of an adverse vote. But Lord, I've spoken about the removal of the checks and balances. This is what I'm talking about. And this is what Nobweze concludes about the good doctor. The tendency to dictatorship, that is at page 625. The tendency to dictatorship of an arrangement which combines in a president full executive power and control of legislation is obvious. It is obvious. It is little wonder, therefore, that Dr. Nkrumah became a dictator under that constitution. And you know what Ghana had to go through for it to attain the stability that it enjoys now. As I conclude, let me again immortalize Justice Ewan Krigler so that he doesn't come back to Kenya when Kenyans, by their own will or through the propulsion of their leaders, decided that their destination must be hell. It should never happen. This is what Justice Ewan Krigler said at page 764, page 764. I'm referring to the report of the Independent Review Commission. Report of the Independent Review Commission on the general election held in Kenya. This is what the good judge said.
What volume are you at?
That is volume 3.
Volume 3?
3. Volume 3.
Right.
Page 764.
Yes, move on.
The last two paragraphs. In order to start trying to prevent a recurrence of the tragic aftermath of the 2007 general elections, and this is where you underline, Kenyans, from president to peasant, will have to do an agonizing stock take of where their country stands. An agonizing stock take. From president to peasant, the pharaonic president who makes traffic stand, to the peasant, the holder, the bearer of the constituent power, pouvoir constituant. They will have to show their commitment to the rule of law and its equal applicability to all citizens, irrespective of economic, social, and political or any other belief. No, the solution does not merely lie in constitutional and legislative changes. The culture of impunity in Kenya needs a fix too. The relevant law enforcement institutions also need to do their jobs properly. IBC must do its job. Parliament must do its job. We have done our job here. My lords, let the court do its job. I plead with you most fervently to dismiss the 4 appeals and affirm the decision made by the High Court. You owe these to the people of Kenya in tandem with the oath you took in accordance with the preamble. I beg to rest, unless there is a question.
Your last exhortation seems to suggest that if we don't agree with you, we are not honoring our oath. But we could go either way. You realize that?
No, my lord, I just asked you to do your job. How you do it, you better qualify to know it.
Absolutely. Thank you.
I'm too junior to be able to do your job. Thank you.
Thank you, Mr. Havi.